very insightful. The questions that we received from you have informed our direction for the next spaces that shall be holding, and we just encourage you to keep joining and attending as we keep the discussion alive. Maybe just for a little bit of context, we are definitely hosting Mr. Edison Karuhanga, a lawyer's lawyer. And maybe for brief context, Mr. Edison Karuhanga is an advocate with over 19 years of experience. He's a partner at Kampala Associated Advocates, and obviously he's passionate about the legal practice, and he is currently seeking our support to stand as the ULS representative at the Judicial Service Commission. Obviously, Mr. Ellison has presented himself as an ardent supporter of the Uganda Law Society, and he has definitely been involved in a number of reformative decisions that have given a lot of support to the ULS in the different decisions they have made, and also really given a lot of support in the reformative decisions that have shaped the legal and the judicial space of Uganda. Well, today we're going to be discussing the case that Mr. Edison Karuhanga is presenting before us, which is the mission-based judges, appointing of mission-based judges in Uganda in accordance with Article 141(2) of the Constitution of the Republic of Uganda. And as we've already highlighted, our sessions are focused on how innovative approaches can be used to transform our judiciary, and in this particular context, how lawyers can be empowered to serve as mission-based judges. I think everyone in this space is very aware that our legal system faces a number of challenges, including the mounting challenges along the line of case backlog, overwhelming backlog. We have a lot of unresolved critical cases that are affecting the justice system altogether. There is indeed a need for bold reforms in these times, and it's more urgently needed now more than ever. In light of that, Ellison has come up with this proposal, which is to appoint mission-based judges that will support the judiciary in dealing with issues of case backlog and unresolved cases, which is affecting the justice system altogether. In light of that, Ellison would like you maybe to give us a brief explanation of your proposal for mission-based judges, and also advise us on why this approach is important in our current times and why it's legal altogether. And with that, we shall get into the conversation. Please, Ellison, welcome you to give your introductory remarks on this. Thank you.
Thank you very much, Mercy. And good, and Alfred as well. And good morning, good afternoon, and good evening to everybody who has joined us from wherever you have joined us from. Mercy, I think that's a fantastic, first of all, thank you for that very kind introduction. And I think that's a fantastic start to this conversation. Why we need mission-based judges and why it's legal. We spent some time on that last week, but allow me to very briefly dive into it. There can be no gainsaying the fact that we need to have mission-based judges operating in Uganda. As we speak right now, like I said, the statistics are screaming injustice in every language, and they are screaming injustice in every tone, and they are screaming injustice in every voice. We have 12,000 pending appeals in the Court of Appeal. We have 42,000 cases which the judiciary classifies as backlog across the judiciary. We have judges sitting on dockets of 1,000 cases each. So we have a challenge, a massive challenge. When you calculate, when you reduce this challenge to the individuals facing the challenge, you have right now in this country the average remand time for a remand prisoner who is being tried in the High Court being 5 to 7 years waiting for trial. Surely that is not waiting for trial. That is serving a sentence. That is receiving punishment before judgment. That is turning accusations into convictions. that has watered down the presumption of innocence for so many people who engage in the criminal justice system. As we speak right now, the average time to finish a land dispute in this country is 10 to 13 years. That is too long a time to wait. As we speak right now, the judiciary released a report that the commercial court is sitting on 44 trillion shillings worth of disputes stuck in the commercial court. Just for context, the banks, the total loans and advances from commercial banks in Uganda is 34 trillion. So we have more money tied up in disputes in the court than the money in the banking system in Uganda today by 10 trillion. That is completely unacceptable. As we speak now, of that 44 trillion, 10.5 trillion is coming from the banking system. So a lot of banks are prepared to lend to the tune of 10 trillion shillings, money that could have been in people's pockets if we were solving our disputes faster. It is bad for business, it is bad for justice, it is bad for the cost of borrowing, it is bad for the victim, it is bad for the innocent. Too many innocent people are suffering too long, and too many guilty people are getting away without punishment. And the reason why we have that system as it stands right now is not because of anything other than the fact that our judicial system is overburdened. A judge sitting to hear 1,000 cases, appeal court sitting to hear 12,000 cases is a burden too big to bear. And we are seeing that burden reflected in a massive health crisis in the judiciary. We are seeing judges falling sick, and if you go to the medical board, you will be surprised at what is at stake right now. So we need this solution. We need this solution. We need a solution. We need to understand that backlog has become injustice. Denied is now as factual as can be. And in Uganda, it is a terrible fact. And we need to fight a war on this backlog. We are not proposing one solution only. And we are not the people who have the solution to this challenge. What we are saying is we need to treat backlog, we need to treat this injustice like a war. And we need to deploy the soldiers who can fight this war. And our argument is it is the lawyers who can do it. As it stands right now, we have 6,000 lawyers. We have thousands of lawyers who qualify to be High Court judges. As it stands right now, we are saying if the judiciary is overwhelmed, let lawyers come in as temporary pallbearers, as temporary clearing and forwarding agents of justice, as the reservists of the judiciary that can be called in to fight this war. It means the lawyers can get in, hear these cases, and go back to their chambers without becoming full-time judicial officers. First of all, they can earn some money. There's nothing wrong with lawyers earning money. Secondly, they can face the challenge of a mission. Say, go and case reduction exercise. You have 100 cases, you have 6 months to finish them in that period and go back to your chambers. That is practical. It is the lawyer earns some money, but it is cheaper for the country. Cheaper because you don't earn a pension, you don't get a car, you don't get a bodyguard, and you don't remain a permanent charge to the consolidated fund. So what we are suggesting there for Mercy is a solution that, in our opinion, is workable. Now you asked, is it legal? And my contention is that it is. Article 142, Clause 2 of the Constitution allows for the President, on the advice of the Judicial Service Commission, to appoint judges if the business of the court so requires. If it's advised by the Chief Justice that the business of the court so requires, if a judge is not available, and if there is a need for it. So it is my submission that the business of the court so requires an appointment of acting temporary mission-based judges who get in, clear backlog, and get out. We need a commando raid on injustice, and the commandos are the members of the Uganda Law Society.
Oh, thank you, Mr. Harrison. Really nice, raised my points. I think the biggest takeaway is that backlog has become an injustice, and we need to fight like a war against backlog and our soldiers and the so-called mission-based judges. But as you may understand, we already have substantive judges, we already have acting judges, and now you bring a concept of mission-based judges under Article 142. So we'd love to, what's the difference between these three kinds of judges? The substantive judges, the acting judges, and now the mission-based judges which you've mentioned. Thank you.
Thanks a lot. To understand the concept, we have to go back into the history. It is my contention, first of all, that it's not me who is fronting, it is in the Constitution. The framers of the Constitution are the ones who fronted the idea of mission-based judges. No one else fronted that idea. It is there. Now, the argument of what is the difference between substantive judges, mission-based judges, acting judges is simply this. Under Article 142, Clause 1 of our Constitution, the President shall appoint judicial officers on the advice of the Judicial Service Commission and with the approval of Parliament. Anybody appointed like that is a substantive full-time judge, and we need more. In making this suggestion, we're not saying we need less. We need more. Now, under the 1967 Constitution, there was a huge role for the Chief Justice to play in the appointment of judges. And it is my contention that after the coming into force of the 1995 Constitution, the Judicial Service Commission was now empowered to ensure that we have a judiciary fit for purpose and working in accordance with the wishes, norms, and aspirations of our people. Unfortunately, and with great respect, a previous Judicial Service Commission in 2005 passed regulations for the 2005 Judicial Service Commission regulations. I think it's actually number 87, that were more in tandem with the 1967 Constitution. And I know this is getting a bit technical, but it's important that we go through this history to understand where we are and what we need to do, because too many people are waiting too long for justice. Under the 2005 regulations, which are currently in force right now, Regulation 19 actually provides for 5 types of judges, not actually the 3 you're talking about.
So all along I thought they were true. Actually, not even all along personally, I thought they were true. The acting judges and substantive judges, until you bring in the concept of the mission-based judges, which have now come to understand from the 2 sessions of this conversation, from the first session and now this the second session. And now you're surprising me with another 3 examples? 4, 5. So I think just like any other person in the audience, we're surprised, I'm kind of surprised of those other 5 kinds of judges. Maybe we may have to go deep into those other 5 kinds. So we get the whole difference. Now we are getting to 8 kinds of judges according to my math, the lawyer's math. You know that lawyers are not very good at math. But we are getting to a very, very many number of judges. Kindly just take us away from that.
Thanks, Al. The 5 kinds of judges are provided for in Regulation 19. Of the 2005 regulations. It is not 8, 5 types of judges. The first one are substantive judges.
Yeah.
Substantive judges are the ones who are appointed by the President with the approval of Parliament. All other judges will then be appointed simply by the President on the advice of the Judicial Service Commission. They are what they call acting judges. Acting judges under the regulations are judges who act in the place of a judge. So for example, right now we have a judge who is on study leave. A resident judge in Masaka is on study leave. While that judge is away, a person is appointed to act as resident judge of Masaka until that judge comes back. That one has been, under the regulations, is called an acting judge. Then there are judges who are called temporary judges. This one, like our mission-based judges. Then there are judges who are called contract judges. And this is now regulation. And then there are judges who are called probation judges. Now, under the regulations, probation judges serve for 2 years. And if they are confirmed, they then become substantive judges. If they have a challenge being confirmed, they serve again for an extra year. So the controversy you're seeing on what are called acting judges are what the regulations are calling probation judges. Now, those regulations of 2005 have not been enforced, or they are enforced legally, but substantively, judicial service commissions generally depart from them. They appoint the way they advise and appoint. That being said, the concept and the idea that someone can serve a judicial office in a temporary capacity, that someone can serve in a judicial office in a contract capacity, that someone can serve in a judicial office in a mission-based capacity, while it is in our rules, it is put there, in my view, in a manner that is highly unconstitutional, because in the way that it's expressed in the rules, it's giving too much say to the Chief Justice as to how those judges are appointed, and yet the Constitution removed the Chief Justice. But what is important is not the technical legalese of who is right and who is wrong, and what is where and what is there. What is important, Alfred, is that under our current legal dispensation, somebody has already decided and has seen the need for temporary, for contract, for mission-based, for probation, for substantive. There is a whole bar out there of lawyers who we need to recruit into these positions and who we need to deploy to solve this challenge. At the moment, it is not practicable for the 2 judges in Gulu Circuit to look over 19 districts. It is not practicable for the judges in Mbarara to be holding on to 2,000 cases each. It is not practicable for us to have 2 judges in the entire civil division of the High Court of Uganda. It is absolutely, they have added more judges, yes. They have added more court circuits, yes. We shall see other reforms coming in, yes. But we also need to realize that if we have a problem of backlog, the thinking that brought us to where we are is certainly not the thinking that is going to solve the problem that we have. And what we are saying is deploy the lawyers as mission-based judges so they get in and say, we have just done a court census. So let's look at the court census that we've done right now, and let's have a backlog reduction exercise. Once we have a backlog reduction exercise, we go in and we get out. The Constitutional Court, I think, this week has issued a judgment about an election petition that lasted 5 years. And said that that's unconstitutional. It's not just unconstitutional for an election petition. It's unconstitutional for the fact that the average remand time in this country is 5 to 7 years. Those people on remand are entitled to a fair and speedy trial. 1 year on remand is 1 year of punishment. Completely unacceptable. Why should you be punished before you are tried? 44 trillion stuck up in the commercial courts, and now you haven't even gone up. You haven't even looked at the sort of land disputes. Actually, if you look at the land disputes and connect them with the criminal situation in this country, you'll be extremely surprised at the correlation. Part of the problem with delayed justice is it causes injustice, it causes crime, and all we are saying is we need to think about this. We have a problem, we need to address it. The Constitution allows us, and this is the final point. If you read Article 142 clearly, 142 Clause 2, it allows. In 1995, someone sat down and inserted these provisions in the Constitution because they foresaw the situation we would be in today. It is important that, so what we're suggesting is not even to amend any law, to reform anything. We are saying remove our law from thin paper and put it into thick action.
Thank you. So, just for clarity, if we now remove our law from thin paper and put it into paper, that means we'll have the mission-based judges, and this will include temporary judges, the contract judges, and probationary judges. Is that the position?
No. Probation judges, what we now call acting judges in the regulations, the challenge with that is the Constitutional Court has found there's an issue of independence. A judge should not be observed. A judge should not be on probation. The idea that your judgments must be agreeable to someone who is going to confirm you means that there is someone who has enough power over you to limit your independence. This is different from some toiling, going to massacre, and also conduct a backlog reduction exercise for 3 months or 6 months, and after that, go back to your chambers. No pension, no bodyguard, no car, no promise of high judicial office. As opposed to someone who is serving on probation, an employee on probation. Judicial officers should not be employees on probation according to the decision of the Constitutional Court in the Kabumba case, because it undermines judicial independence. In the 1967 Constitution, it was there, it was provided for. That was removed in the 1995 Constitution. And so, we're not saying that there should be probation judges. We don't want to see judges on probation. What we want to see is mission-based judges. We want to say, instead of a judge, right now what happens is this: you have a criminal session. In a criminal session, it means that the judge leaves where he has been, say a judge of the Civil Division of the High Court. He leaves the Civil Division of the High Court and goes to Nebi or Arua to conduct a criminal session in Arua. All the cases he leaves them behind and creates backlog. We are saying, instead of creating those wherever you have manpower shortages, there are people ready and willing to be deployed. These people are called advocates. Deploy them, they finish that session, they go back. It's not happening every day, not in sessions. There's no reason why someone should wait for his session when he should be tried every single day. The way we're working actually doesn't make sense to most people. And it certainly doesn't make sense to people seeking justice. And we need to start making sense. And all we are saying is, let's be sensible in the delivery of justice.
Well, thank you, sir. I think now that brings us to our topic of your approval debate in the appointment of judges, or vis-a-vis mission-based judges, contract judges, and acting judges. But just like any person who is in notice with having very many questions, which you may in the meantime send in the chat section, or send them in my DM. You could ask Mr. Rago will answer them later on. I know Michael also has questions along, but I'm working very hard to ask you more questions regarding this whole concept. So, Mercy, please.
Yes, thank you very much, Alfred. I think for me the question that I have in light of Ellison, your previous submission on the fact that too many people are waiting too long for justice. I think anyone in the audience will be asking themselves, what specific benefits do clear performance targets and defined roles that when someone is being appointed as a mission-based judge, they are given a clear target and a defined role? What benefit does this approach bring in light of the existing issues of case backlog and having many critical cases that have no judgments delivered thereunder? So I want to understand, what unique benefit does the approach of appointing mission-based judges bring in light of these challenges we discussed?
Thank you for that. Thank you for that. The mission-based judges are judges on a mission. So the mission has to be defined. You tell him you're coming in, or her, you're coming in for this purpose and this period. Finish the purpose in the period. The judiciary actually does have performance standards. For example, I think the judicial standards provide that after a case is had, you must not take more than 60 days to deliver a judgment. But because of the nature of the overburdening work, there are many cases that are pending judgment for 10 years. 10 years waiting for the judgment. 5 years waiting for the judgment. When the standard is 60 days. A case becomes backlog going to spin in the system more than 2 years. There are 43,000 instances, according to the last report of the judiciary, where that has happened. That's completely unacceptable. And we're not saying that the judges are working themselves hard, they are falling sick, they are not delivering, not because they can't deliver, but because the system is overburdening the people who are serving in judicial office. A mission-based approach is a simple, straightforward approach. By the way, it also applies to magistrates. You have a mission. In Arua, you are a judge in the family division in Kampala, go to the criminal division in Arua, finish all the cases in that criminal session in a month or two. And many cases are actually disposed of in that month or two. We are saying lawyers can be those mission-based judges. Don't solve one problem by creating another problem of backlog. And what we are saying is already in the law. So this approach is that once it's mission-focused, you conduct your mission, you get out. You conduct your mission, you get out. There's also so much talent, so much knowledge, so much assistance the bar can render. Lawyers already serve as arbitrators. As arbitrators, they are providing judgments that are not even under the law of Uganda appealable. You can agree to go before a lawyer as your arbitrator, and once he decides the matter, you can't appeal. You can only apply to set it aside in the event of serious abuse of the office, and it's going to be very rare for you to succeed. Lawyers are already acting as mediators. They can sit with you, talk to you, and settle your matter. Lawyers are already acting on state brief. So lawyers already provide critical roles. Lawyers can serve as prosecutors, by the way, in the event the prosecution arm is overwhelmed. So we have a role already to play. We are saying, let us play this role not just at the bar, we can also play it on the bench. Where, of course, they'll charge for it, earn at whatever rate they're earning, but they don't earn a pension, they don't get a bodyguard, they don't get a car, they don't get the fuel. At the moment, one judge costs you a car, a bodyguard, fuel, a research assistant at the level of a magistrate, a clerk, a secretary, an entire chamber. Right now we are saying, let's find the infrastructure the judiciary has, we sit in it, we resolve the matters, we get out. We need to change the concept of justice in Uganda. How can justice be delivered? You've seen many cases where justice, people are waiting. You say you're waiting for the judge. You've gone up country or you're in Kabale, you're waiting for the judge, or you're going to Kabale for a court case, and as you're going to appear before this judge, you see the judiciary car driving from where you're coming from, because he has now got an urgent matter this side, and you have to go that side to adjourn. Those sort of delays, we need to start thinking about how to make sure that this system is responsive to the people. Article 126 says that judicial power is derived from the people and shall be exercised in accordance with the wishes of the people. Who wishes for justice to be delayed? Who wishes for justice to be denied? Who wishes for justice to be a commodity that only a few people can have access to, because the system is too broken, too slow, and because the men and women who are serving in that system are being put on such undue pressure, they're being asked to perform beyond human capacity? I can tell you who wishes for that. Absolutely nobody. And it is time to deliver for our people. And for me, the solution is we need a solutions-based approach. Unfortunately, the Law Society is currently engaging in a process of having a debate about our judicial system through the selection of the Judicial Service Commission. And for us, this is one of the things we are proposing as candidates. So this is an idea that is in our law, and we're building up this idea as the lawyer's lawyer. Thank you.
Thank you, lawyer's lawyer, for that elaborative discussion on this. You really need the solution-based approach to address case backlog and enable easy access to justice. And yeah, probably the mission-based judges will perform that role. And talking of the mission-based appointed under Article 42.1, provision on 2-year contracts instead of receiving substantive status. So basically, This Ontario contract would have been appointed under Article 142.2, but they are appointed under Article 142.1, and we've given clear contracts. So, from my head, this contract approach raises challenges such as lack of continuity, is diminishing independence, made me thinking if I perform on these two contracts, then I may be renewed. So there's that independence probably will be affected. And then there's looking at accountability. Over the person who gave you the contract vis-a-vis to renew it. So you are so much so accountable to that person instead of the public who are serving justice. As compared to the commission-based appointments who come with the clear performance targets and defined roles. So, as a person who is coaching this area of commission-based judges, how do we rectify this discrepancy and address the challenges to ensure that we have a stable, efficient, and accountable judiciary? So, this is first as a person who is fronting this area of commission-based judges, and then as a person who is supposed to represent the Government Society members in the Service Commission. How do we rectify this discrepancy and address the challenges to ensure that we have a stable, efficient, and accountable judiciary? Thank you. You may take it from there.
Thanks a lot, Alfred. You know the appointment under Article 142, 1 of the Constitution, which is appointment of substantive judges. How you can use that process to then put someone on probation is currently before the Constitutional Court. Actually, it's currently before the Supreme Court. It was determined by the Constitutional Court as being unconstitutional. And now the Supreme Court will have its say on whether that's constitutional or not. But the challenges of that process, constitutional or not, are very clear and apparent. Number one, the first challenge is that putting judges on probation clearly affects issues to do with judicial independence. But we don't just have a challenge, we have a challenge of independence, but we also have a challenge of efficiency, a challenge of delivery, a challenge of how to make things work. So first of all, we are not in support of probation. What we are suggesting is solutions to existing problems. We are saying let us enhance the opportunity of our people to receive fair justice. We are saying let us enhance the opportunity of our people to ensure that their cases are heard, such that justice is not just done, but is seen to be done. At the moment, with backlog, what happens is not only is justice not done, justice is not even seen at all. It doesn't turn up. It doesn't turn up to the, it doesn't turn up to the show because the people who are asking to do it are overburdened and overwhelmed. So for me, the first solution must be to understand that a courtroom is not a building, but courts are services. And once we understand that the courts are services, then we must see how can we deliver that service to the last man, to the last woman. How can we deliver that service to people who are urgently and desperately in need of it? If we understand how to do that, those are structural, systemic issues. The framers of our constitution, I will keep insisting, already had an idea of how to do it. Let us get what our forebearers said and put it into action. This must not be confused with the issues around judicial independence and judges on probation. One of the challenges we have is that sort of debate can end up getting us lost, losing the forest for the trees. We need to ensure there is delivery, there is good judicial performance, and there is delivery to our people. The courtroom is not a building. The courtroom must be a service. We must never again hear that a judgment took so many years because the court didn't have a place to sit. Justice cannot be left seatless. There's a quote someone once said that we must not tell our people that the bank of justice is bankrupt, that the check upon which they signed for justice was bounced. Justice has no bounced checks. And we must make sure that every time our people turn up with their check in the bank of justice, that check is cashed. Because a bounced check is a criminal offense.
Thank you very much, Alison, for that. I think whereas justice is very important, I think the other very critical principle in the justice system is judicial integrity. And in the minds of someone in this space, they're thinking, if we have a lawyer in private practice who now has switched the role to being a mission-based judge, how will we maintain things such as impartiality and judicial integrity, things such as ethical principles that ordinarily most judicial officers are trained probably to have? What proposals, for instance, would you have in place to make sure that those judicial principles, which are very critical for maintaining and delivering justice to the people, are actually maintained while implementing this particular program of appointing mission-based judges?
Okay, first of all, thank you so much for that, Mercy. You see, first of all, the judiciary is picked from the law society. People who qualify as lawyers are the people who are picked as magistrates and judges. So that is the training that people have. Those who are picked as lawyers are the ones who serve as magistrates and judges. That for me is the first point. The second point is the judicial oath will be taken. You will take that oath to serve for the period that you will be serving. The third thing is that you will of course be subject to the disciplinary processes, and removal of a mission-based judge is a lot easier. Under the Constitution, they are removed. You can't remove a judge as simply as you want to. If you wanted to remove a judge right now, what you would have to do for a substantive appointment is you have to make a complaint to the Judicial Service Commission. You would confirm your complaint and would have to forward your complaint then to the President. The President, on receiving that complaint, will have to appoint a tribunal to investigate the judge. If the tribunal finds the judge guilty, the report from that tribunal will go back to the President, who will then forward it to Parliament. Parliament will then debate it, and if Parliament decides to remove the judge, you then send it back to the President. That's the process of removing the judicial officer. A mission-based judicial officer is simply removed on the advice of the Judicial Service Commission or on the termination of his period of appointment. That, however, or her period of appointment, that, however, needs to be seen in the context of delivering justice as a substantive commodity, as a substantive item, as a right. The Constitution provides that every person is entitled to a fair and speedy trial before an independent and impartial tribunal. We always argue this is not an independent court, this is not an impartial court, this is not a fair tribunal. But many of us have given up on the speedy. You will hardly find anyone in Uganda saying this is not a speedy trial. We don't expect them anymore. It is like practice has amended our Constitution to remove the right of justice being delivered in a timely fashion. That must not be allowed to continue. Now, would a mission-based judge lack the independence and impartiality required of a judicial officer? I don't believe so. Many countries use them. I think in England they use them, they call them deputy judges. In South Africa they call them ad hoc judges. In India they use them, but maybe in a more limited fashion. In Uganda we have used them, but in the context of the judiciary. In the case of General Tinyefuza in 1998, Justice Sekonda Ntende was appointed from the High Court to the Court of Appeal as an acting judge to hear one matter, the Tinyefuza petition, and go back to the High Court. A few years ago, Justice Sekoko, Justice Kitumba, Justice Okello, Justice Odoki were appointed after their term had expired as acting judges of the Supreme Court because the vacancies in the Supreme Court were empty. We've seen the use of this method among judges, and we are saying expand this method of efficiency to lawyers, because once you remove a judge from his docket in Jinja to hear an involving constitutional matter in Kampala, what happens? Backlog. Backlog cannot be the guarantee of independence, because that is not going to be that there will be no independence there. What we need is a system that is delivering justice for our people, and that is doing so in a manner that is efficient and timely. So what I am suggesting, Mercy, therefore, is not anything against independence. What I am suggesting is let us enhance independence while improving efficiency.
Thank you very much, Edison, for that very detailed response. I think that it makes it clear to a lawyer that intends to join this particular program, but also for someone who wants to know if they can trust the process, but also for the other people in the judiciary to understand that these particular people would be coming for a particular mission, and they would be held at the same standard as any other judicial officer at the judiciary, and therefore there is very little room, obviously, to question their credibility once they are appointed in these temporary positions as mission-based judges. I'll invite my colleague Alfred to ask the next question, please.
Thank you, Mr. and Mas. Now, the conversation is really getting interesting, and at this point, I'd like to dive deep into our major topic for today: the due approval debacle in the appointment of judges. That's Article 142.1 verse Article 142.2. So, what potential drawbacks exist in our current due approval process, where both judges appointed under Article 142.1 and 142.2 are approved by Parliament, yet ordinarily, or from the understanding you have given us, or even from my own understanding of reading the Constitution, those appointed under Article 142.2 are not supposed to be approved by Parliament, the so-called mission-based judges, which we are fronting now. So, what potential drawbacks exist in that due approval process, where both judges in both articles are approved by Parliament, and how can we address those issues, which the potential drawbacks which come along from the due approval process? Thank you.
The Constitution provides for how people are appointed as judicial officers. When you go to Parliament, what happens is the Judicial Service Commission advises the President that you should be appointed. The President then appoints you, and Parliament approves you. You must therefore sit at that judicial office until you attain an age of retirement. Parliament is an important vetter to make sure that by the time you are going to sit in permanent judicial office and determine the disputes of Ugandans, you have gone through a proper vetting process by the elected representatives of the people, whatever drawbacks that may have. Article 142.2 is not giving you a permanent judicial office. It is bringing you in to resolve an issue. Resolve that issue and go back. That process is supposed to be a lot simpler. If the business of the court so demands, the Judicial Service Commission is supposed to be informed, and after being informed, it's supposed to tell the President, appoint so and so in an acting capacity. The problem we have right now is that there are some appointments which have been made, which are of an acting nature, but they are taking people to Parliament. Therefore, the intention is for them to sit in a permanent judicial office, and they are then turning that into a probationary appointment. Can probationary judges be independent? I have my serious doubts. But nonetheless, that's a question that will be before the Supreme Court. the important thing is this dual debacle, this dual approval debacle, as you guys have coined the phrase, is not so much that we don't want Parliament to approve, but we are saying that the moment you approve, that person can then not go and act in a judicial office. That person must be holding a substantive judicial office. The moment, however, we limit this issue into whether people can be holding permanent or non-permanent offices, we miss the forest for the trees, we miss the bus. The bus and the mission must be to deliver justice to the last man, to make sure justice is seen and is done, and is seen to be done. At the moment, it is not seen at all. And that is a fundamental challenge. So that is your dual approval debacle. In my humble opinion, what we are dealing with is a thinking that is noble for whatever, that people are working hard to appoint more judges. In the last few years, we've appointed more judges than we've appointed before, built more courtrooms, try to ensure that there is higher access to justice, but that challenge is not going to go away with those sort of measures. We need to be creative in how we are doing it. We need to infuse technology in this process, and we need to make sure that we make a better use of the lawyers in this country who are able, willing, efficient, and fantastically trained to come in, solve the problem, and get out. The lawyers are the real commandos of justice.
Yeah, you raised very many concerns which come along with the new approval debate. So, maybe for clarity, how can then adopting the mission-based appointments and Article 142 overcome those issues which come along with the new approval debate, where judges in both is Article 142 and 142 are approved by Parliament?
Sorry, you said how can we do what?
Let me rephrase the question. You see, the dual approval process has various issues which you have some already. Sorry, my network was off. What you're saying, the dual approval process has several issues which you have pointed out in your discussion. So now my question is, how can adopting the mission-based appointments under Article 142.2 help us to overcome those issues which are brought about by the dual approval process? You get me right? Yeah.
We must remove this idea of acting as a form of probation. This for me is the first thing. The idea of probationary judges. Let us observe you, let us see how you work, and if we like the way you work, we appoint you. The idea, of course, was to make sure that people who access judicial office must be effective and all that. The problem, what we have seen, is a total lack of independence. And lawyers will tell you that we are seeing this in practice. In many instances, I don't need to go into examples, but in many instances we are seeing it in practice. Judges, for example, are supposed to post their decisions online, and you'll find many people who are just accessing judicial office on a probationary basis are a bit worried about being subjected to the scrutiny of the bar, and they prefer to play it safe. And acting judges therefore end up playing defense and playing it safe. Yet the law is the strength of the common law is its eternal youth. It must always transform, always evolve, always face the challenges it's meeting. And the challenge with probationary judges is, will they have the courage of their convictions? And many times you're asking too much for someone on probation who you've taken away from what he has been doing for his livelihood to come here and risk it all. While a mission-based person, a lawyer, an expert in commercial practice, an expert in intellectual property, who takes time off to sit in the commercial court and hear a few intellectual property cases and then goes back to his chambers, is not relying on this judicial office. So the first thing you have to realize is the appointment under Article 142.2, we must not use it we should not use it for probationary judges, but we must use it for mission-based judges. We must use it for the judicial commandos. We must use it for the people who are going in to raid the camp of injustice and make it empty. Let's start having decisions. Let's start having many decisions. If you are able to tackle backlog at the High Court, it will be a lot easier at the appellate courts. If you're able to tackle the challenges in the magistrates' courts, it will be a lot easier at the High Court. The base of the pyramid needs to start to see justice, because most of us access our courts at those levels, and we need to ensure that the people who are getting there are equipped, are well trained, are knowledgeable, are versatile, are independent, but are able to carry out the task that is before them.
Well, thank you. I think the biggest takeaway is that the age of probationary judges should be removed, because it creates total lack of independence. I'll have to take note of that. Yeah, Master keeps telling me he's feeling several questions from the audience, and so I have no way to keep sending in the question from either the our inbox or on the comment section. At this point, I would first call Master to ask the questions he's receiving from the audience before we could proceed. So those who have questions can keep saying them as we come towards the end of the space. Those who have questions, you request for the microphone to speak. But at this point, I like for Master to really share the questions receiving from the audience before we proceed with that.
Yes, thank you, Alfred. I think the question here is, earlier on, Edison, you had mentioned something about this particular approach of appointing mission-based judges being implemented in countries like the UK, I think, and South Africa. And I think the question here is, what was done in those countries when they were appointing this particular mission-based judges, and what lessons can we learn from them as we adopt this particular approach here in Uganda?
I think in England they have what they call recorders, and they have what they call deputy judges. And deputy judges are simply barristers or solicitors who hold rights of audience, as they call it, who simply barristers or solicitors are the lawyers who have access to the courts and who have rights of audience, and then they can appoint amongst them a deputy judge. In England, how they do it is you serve on a part-time basis. And on a part-time basis, when you serve as a judicial officer, what happens is you serve for, I think, a specific number of weeks in a year. So you go, you practice, and then you have like maybe 3-4 weeks in a year when you can come in and serve. In South Africa, it is really exactly what we are proposing. It can be done like that, but also it is a limited intervention. You come in, you do particular work, and you go back. I think they call them ad hoc judges. Around the world, in the United States, I think they're called pro tempore. I think pro tempore judges. I'll get the actual phrase, where they say lawyers also go in and do this. In many jurisdictions across the world, this is a model that is working, where you are getting lawyers to come from their practice, hear a matter, and go back to their practice. So your practice remains alive, and at the same time you get judicial experience. Later on, maybe someone can be appointed to a full-time judicial office. It's also a place where you can see. Also, for lawyers who want to do it, there are many people who wish to serve in the judiciary. When they get there, they have this anticlimax. They get there and this is really not what they wanted to do. But if someone goes in as a mission-based judge, and he realizes that, or she realizes this actually isn't for me, it's better for them, but it's by far better for us as the consumers of justice. So what we are looking at, therefore, as an approach is what works really across the world. It's really been working in the UK for donkey's years. It's been working in South Africa from time immemorial. They're really the places that I've looked at and even spoken to lawyers there, and seen that this is something that for many of them makes the wheels of justice turn. Right now, you're putting too much of a judicial burden on too few people, and then they have the unaware of all the challenges, and then they have that mantra of workers, that mantra of we the uninformed, working for the inaccessible, are doing the impossible for the ungrateful. Someone says, I'm here for all these hours working and nobody cares. But he's not clear. He has 1,000 cases. He has cleared 100. He says, I've cleared 100, but the 900 are still unhappy. We can't expect people to work the way we're expecting some of our judicial officers to work. And they should work, but there's a whole bar that's right there, sitting there ready to start working for them in a way that's profitable for lawyers, but that's cheaper for taxpayers. And so for me, this method makes sense, and we've seen it work. It actually works in England. It actually works in South Africa. There are still, of course, other challenges that can lead to backlog in many of those jurisdictions, but they are certainly facing the challenges head-on by using the available arms and legs of lawyers that are present. And that's all we're saying. We're saying, guys, we have a problem. Let's start thinking of solutions to the problem that we have. The thinking that brought us here is not the thinking that's going to take us across the line. What we want to see is results, is justice, We must understand that injustice anywhere, they say, is a threat to justice everywhere. But injustice is justice too long delayed. Injustice is justice denied. Injustice is the fact that the average remand time, and forgive me for saying this again, is 5 to 7 years. Injustice is the fact that 44 trillion is stuck in the commercial court, more money than the loans and advances that are going out. Injustice is a threat, and it is a threat that we need to meet head on, and this is one way that I propose we meet it.
Well, thank you, Mr. Harrison. Indeed, the thing that brought us here is not the one that will take us across the line. So I was here, I got the word from one young lawyer. So specifically, was like negative. I want to quote what he said. But so I am going to feel more. But that brings me, because these judges, I think, are still on graphite to people 15 years experience or 10 years and more. So that brings me to the next question. How will this integration of the mission-based judges, first, how will it create additional career opportunities for the legal professionals who have, because by 15 years, you have already made your mark in the legal fraternity and your bit seasoned. So, how will it create career opportunities for those ones who are seasoned? And then for these young lawyers, how will this aid also create a pathway for young lawyers to build experience? Thank you.
Of course, like I've said, for the young lawyers can be magistrates. In fact, what I've established is that there are so many young lawyers who want to be magistrates in Uganda today. And one of the biggest challenges that young lawyers face is the process of becoming a magistrate. And in fact, one of the biggest challenges young lawyers face is the process of becoming a magistrate. So many apply for so few places. On top of that, they have no understanding of this process. There's no transparency, for at least according to them, as to how they are selected and how they are not, how they are shortlisted and how they are not, who gets interviewed and who doesn't. Some of them, some of the horror stories we hear about young lawyers seeking judicial office are just incredible. But at the same time, we have, I think, about 260 magisterial areas. So if you made those 260 chief magistrates, you need a number of other magistrates there in each magisterial area, and many people, and we don't even have enough magistrates to fill, I think, even half of the magisterial areas. I'll get the numbers properly. So first of all, for young lawyers, what we are saying is that if we are not able to fill the entire lot, at least let us have this same thing applying to magistrates. And Regulation 19 of the Judicial Service Regulations allows for it. But secondly, for young lawyers, we're also saying let's ensure that the process of recruitment of judicial officers at magisterial level is transparent and is clear, and they have a clear understanding of how they are getting in and how they are getting out. But the other thing for young lawyers is that right now, if you had a child, because the statistics I've given you are so incredible that if you had a child today, God blessed you with a kid today, and you are handling a case, you may start seeing your first judgment when your kid is going to sit PLE. And so you have some young lawyers who have now specialized in many other areas of practice. So first of all, the issue we need is that once we have more judges delivering justice, more people have more flight hours. They call them, I think, flight hours. More young people have more time to start and finish their cases in a good enough time to create a better enough legal brand for themselves in this market. For the practitioner, like I said, the expert can come in and give his expertise. The person who wishes to be a judicial officer can test the waters. The person who wishes to serve can serve. The one who wants to earn from that process can earn from that process, as long as they earn the above the table money. The important thing, though, is not just for the lawyers. What we are proposing, we must remember that we are the only people by law entitled to address the courts. So while we are 5,000, we have 45 million clients. Justice is not ours, it is for the clients. The causes are not ours, they are the causes of the people we represent. And the people we represent surely demand justice. They demand it now, they were promised it by the law, and they must be given it by those people who are entrusted with making sure that we breathe life into law.
Yeah, I think the young lawyers question has been answered vis-a-vis the one for senior lawyers. Probably everyone has a win with the idea of this mission-based judges, from the lawyers and even from the people who access justice. And at this point, I know myself technology a lot, and wondering how we can have this technology put into the mission-based judges idea. So I would love to call her to pose a question.
Yes, thank you, Alfred. I think we cannot undermine the importance of modern technology in improving judicial efficiency here in Uganda. And I know that the judiciary has adopted several mechanisms, including ITMIS, entertaining virtual hearings. So I think it's important for us to understand how these particular steps that the judiciary has taken in adopting technology will marry or complement the approach of appointing mission-based judges in Uganda. How will these two complement each other to ensure that we achieve a higher level of judicial efficiency here in Uganda? Thank you.
Thanks, Marcy. I think that's a really good question. Technology is certainly a game changer in many fields. So technology is certainly a game changer in many fields. Think about it. What we can do today, even the mere fact that we can have this conversation with the people we're having it with, in the places where they are, is a result of technology. We cannot continue to have an analog court in a digital world. We simply cannot. And to the credit of their lordships, there is an electronic case management system, the ECMIS, which needs to be rolled out to the whole country as a starting point. That is for case filing. But we're going to start seeing virtual hearings. We also, one of the reasons why one famous judgment was delayed was because the court didn't have premises. Right now, technology doesn't need the people in a meeting to be in the same room. The people in a meeting can be in different rooms. The people at a court hearing don't need to be even in the same country for the court hearing to happen. Technology, therefore, we need to start seeing not just virtual filing, virtual hearings. Where you sitting, we did it during COVID quite effectively across the country, where people were sitting in their homes, fully robed at home, making arguments to the courts. We need to see a larger rollout of electronic hearings, such that people who are not available can participate in their hearings. And that means technology will help us move away from the idea of court as a building and bring us closer to court as a service. Allowing even mission-based judges to hear cases where they don't need to have their office ready, because they already have an office where they are sitting, they just deliver what they are delivering and they move on. So for me, technology is an important solution. Technology, virtual filings, and you can see with the birth pains it had some trouble in the beginning, the case management system. But you're seeing some improvements there. And give credit to the judiciary for that. What we need to see is more use of technology. And there's basic technology that can really help to deliver fast-paced justice. You look at examples from courts like Singapore, Hong Kong, and the sort of things that technology has done for justice there, and it's just mind-blowing. And we need to start having mind-blowing technological solutions right here at home, solutions that deliver. So technology is important. And that's the thinking we need to start having. We need to treat backlog as a crisis, and we need a war on backlog. And once we have a war on backlog, we'll then be able to deploy the commandos of the judicial system, who are the lawyers and members of the law society, to come in and solve these problems. Yeah.
Yeah, thank you, Mr. Edson. Whereas in the interest of time, I'll take the questions from the audience. Mr. Duncan, you raised your hand to ask a question. You already made a speaker, you may pose your question. Mr. Duncan poses this question. Those who have questions and you want to ask, you can send me a request to speak, I will allow you. And those who have others will inbox me, will soon pose your question to Mr. Edson. So Duncan, please proceed with your question. Thank you. So much Duncan for your question. I will allow Mr. Edson to respond to you. Thank you.
Okay, Duncan raises an interesting question about independence. And he says, do mission-based judges inherently solve the challenge we have now of independence? I want to address your question in two parts. And Duncan will forgive me. I want to address your question in two parts. And the first part is, one of the big challenges we have in the way judicial office is accessed. There's an issue you're calling it an issue of cadre judges. How do you solve the problem of the cadre? With a mission-based judge approach, if a judge is he comes in to solve backlog or to solve a particular problem, and he's not able to deliver, it will be very clear that he's not able to deliver, but you're not stuck with him forever. So for example, if Ellison comes into the judicial office and lacks judicial independence, at least you know that he's there for a few months and then you are redeemed from the fellow. But more importantly, one of the things that this method allows, it allows us to create a pipeline of talent. You see, right now, if you look at what's happening in appointment of judicial officers, one of the bigger challenges we have is that there is what they call sitting tenants. Sitting tenants are people who are already in the judiciary. And the idea is that we must promote people who have made a career in the judiciary. And then you have people who spend a lot of time at the lower bench doing incredibly great work, but they fight so hard to become High Court judges that by the time they do reach the office of the High Court judge, and I say this with great respect to many career judicial officers, by the time they do reach the office of the High Court judge, they're actually tired. and the exercise of judicial, the exercise at the High Court bench is an exercise in retirement, and they don't want to risk. And then you have issues of independence arising. Then there are also issues, as you call them, of cadre judges, people who are appointed specifically because they are supposed not to be independent. I think that's what we mean by cadre judges. The mission-based approach means we are really opening and democratizing access to the bench, and we are using expertise. I'm not even saying we stop appointing substantive judges. We must even appoint more substantive judges if we must. But the mission-based approach allows us to get a lot more talent available to solve people's problems. Now, your concern is independence, and we must make sure that our judiciary is independent and efficient. Once we don't have those two things, we'll definitely have a problem. The solution to judicial independence must be the protection of the judicial office. That's one solution, and that is why we are not comfortable with the idea of judges on probation. Regarding the larger issues of Ellison being a lawyer for whoever he was a lawyer for, it doesn't matter whose lawyer is appointed. I recall there are very many. I was going to give an example of a judge and his client, but I've thought about it. Do not rub off onto the idea of mission-based judges. We must not lose the baby with the bathwater. Thank you.
Thank you, Ellison, for that very elaborate response to that question. And I think we've got another question along the same lines, which is really, there is need for judicial continuity and stability. If we do have these mission-based judges appointed and coming in and out, so we have one appointed for 3 months, another for 6 months, they go back to their private practice. Of course, we already need to deal with judicial efficiency. How are we going to balance this out with the need for judicial continuity and stability? What is your opinion on how to balance those two?
We are not asking for instability, but there is no stability and there is no continuity in the fact that we have 42,000 cases in backlog. Even those who are waiting are entitled to justice. There is no stability and there is no continuity from the fact that we have 44 trillion shillings tied up in the commercial court. There is no stability and there is no continuity in the fact that remand has become a sentence and that an accusation has become a conviction. There's no stability in that. The stability of our justice system lies in its ability to churn out the cases and to deliver justice to the last mile and to the last woman. The stability of our justice system lies in its ability to be resourceful, lies in its ability to be versatile, lies in its ability to have court hearings even without court buildings. The stability of our justice system relies on the fact of taking justice as a service to the people. We call people their lordships because we expect a lot from them, but we're not supposed to load onto them challenges that are even affecting their health. There is absolutely no stability, in my opinion, in injustice, in delay, and in backlog. What we are proposing is the stability. And the stability we are proposing, you have a criminal session, for example. You hear 200 cases in 2 months. Disposal of cases does not cause instability, because after all, a judge who is appointed once hears the case and finishes it. And when he finishes it, it goes to another level on appeal. There is no instability in what we are proposing. The only instability is the instability of injustice. The only instability is the instability of delay. The only instability is the instability of convictions without trial, called remand. The only problem is we are suffering. Ugandans are suffering from a lack of access to justice, and we need to make sure that justice is accessible to the last mile and to the last man and woman.
Thank you, Edison, for that. I think what we're hearing is that the current instability that exists in our judiciary is overwhelming, and therefore implementing this particular approach would not cause any form of instability or create a level of lack of continuity in the judiciary altogether. And I hope that answers your question to the listener who asked this question. I will now give it to Alfred to give us some closing remarks as we come to the end of this particular space.
Because you know to come from Lagos. And I have one question which I've got from the audience, and I need them already before this is present. So, Mr. Singh Anthony, our Vice President of Member Society, has been the space for all this long. Even the rest of also Nicholas Opio, who have been, this one has been on the forefront of people accessing justice, I think, for the biggest part of his career. And I thank you for being in this place for this long. Just have one question which I have received from the audience, and we maybe have parting shots after. So this one, I think he has got to understand this idea, and he's really wondering what immediate steps should the local community advocate for to reform the appointment process and ensure that our judiciary are improved to meet these challenges. So, from what I understand, you are saying that we have the solution to these challenges of the commission-based judges, and it's now upon us, the local community and everyone, all the stakeholders, to have this working as soon as yesterday. So this when it was the question of what immediate steps should the local community advocate for to reform the appointment process, this due approval debacle which we have been engaging in. So to ensure that our judiciary goals to meet these challenges, which probably now include the case backlog, access to justice, bringing court, not court as court, but the services of court because of the people and everything. So I will have your take on that as we close. Thank you.
Thanks a lot, Alfred. I'm very grateful for that question, and of course there are some immediate steps. We are having an election for the Judicial Service Commission. The first immediate step maybe is to vote for the lawyer's lawyer as a solution. And I don't say that lightly. You see, one of the big things, and a lot of people, there's a lot happening around the Uganda Law Society, and it's good to see the Vice President on the space. And I welcome him to it. I hadn't actually seen him. Thanks for pointing that out. What the UNS has done by saying, let us have an election to choose, and by bringing this debate, is a massive contribution to seeing how we can improve judicial service in this country, by shining a light where it needs to be shone, and by ensuring that in who the lawyers are selecting, there is a process of democratization. That is one step. So participate in the upcoming, soon to be Judicial Service Commission elections. Some people are trying to stop it, but as you know, nobody can stop radio. But that's one thing. The other thing I think is it's already in the law. We are not asking for things. We are not saying we need to sit down, amend the constitution. I've seen some people proposing constitutional amendments. We are not amending the constitution. We are not changing rules. But what we are proposing is already in the constitution. Certainly, we would have to write rules on who can access judicial office in this way. And we can write those rules because under Section 27 of the Judicial Service Act, it's the Judicial Service Commission that writes its own regulations. So this is something that we need to start on. We need to have this conversation. I can assure you, I have toured the country, I've spoken to many colleagues, both at the bar and on the bench, and I can tell you that there is a very strong desire and feeling for us to change the way we are working and for us to start delivering. Because if we don't start delivering justice for people, we are all going to have a massive, massive risk to ourselves. So in answer to your question, we need to continue with the democratization such that we continue to have the sort of discussions, painful some of them may be, that are able to take our system to the next level. And I also am very happy to see the Vice President on, and really to congratulate the Law Society for having pushed through the idea of this election that has given us an opportunity to make this case to the members of the Uganda Law Society. And also maybe to ask the Vice President to send our best wishes to the US President, wherever he may be.
I think the best president has done. Well, so I have my short parting remarks, and this just to thank you to everyone who has been on this space from 7 up to 8:30. I knew you all had better things to have done during this period, but you opted to join us. These questions are still ongoing. We shall have a similar space next week on Wednesday, as with another topic, but still digging deeper into this education-based judges. We'll be happy to have you again on the space, and I will still invite Mr. Elson to speak to us on that space. And we will bring even other than God. I would like to ask Mr. Simu Anthony, I don't know if you have, I am sure I meant to understand you have a message from Gano side, because like to speak to us as a person who was also he was before coming to that was an issue. Gano side, I know you have been on the point of developing everyone access justice through the legal aid. From what I have known, you have been working with the way from the Gano side, and I know everyone being here, you have been from almost all over the country working for access justice, and I'm sure this idea is really in alignment with your values. But then at this point, as the president of Gano said, and in the absence of our president who is in Rwanda, I'm sure you may have a message for us. And you say your name to speak, yes, in case you're able to, you can accept us, and yeah, have a word from you as we close. From my side, yeah, I once again thank you for joining the space, and I invite you next week or Wednesday, same time as we keep. We advance this age of the mission-based judges and we understand it better. I hope next time Mr. Session will bring people from other jurisdictions who are already getting the benefits of this education-based judges, who understand this practicability, so that they speak to us. Maybe we have got to understand the very part of it, but we need to talk to people who are doing practical and see how it applies. So I hope when you have enough space, they will be able to come to speak to us. Thank you. Mercy, you may take one before this session comes to our part.
I think mine is to say thank you very much to my co-host Alfred, and thank you so much Edison for obviously giving us all this information and answering our questions quite elaborately. I would like to still invite all of you to join us next week on Wednesday as we continue to dig deep into this discussion and have some interesting guests hopefully for our next session to give us practical understanding of how this particular appointment of mission-based judges works in other jurisdictions. Thank you very much, and I wish you all a lovely evening. Ellison, maybe you could just come in and give us some closing remarks as we close out on this particular space.
It is my great honor, Mercy and Alfred, for your time that you've given us. I do promise I will be bringing lawyers from other jurisdictions next week. I'll try to ensure that our lawyers from other jurisdictions can come and show us that what we are saying is working. But I am especially grateful to everybody who has joined us from wherever they have joined us from, who has sat with us for the better part of an hour, who has shared their time, their patience, and their thoughts with us. I'm especially grateful that we are having this conversation about the Ugandan judicial system and about how to make it work for those of us who earn our life keep from it, and for those of us who desperately need it to save them, those who are suffering injustice, to ensure that victims are avenged, that criminals are punished, that the innocent do not suffer, that justice is seen, justice is done, and justice is seen to be done. But most importantly, I am most grateful for people who have come I'm very grateful to the members of the Uganda Society who will listen to us. And it is my singular honor that I'm here, and we shall continue to be here to make the case for how we can make the judicial service in this country much more pleasant for the people of this country. To everybody who has joined us, from wherever you joined us from, good morning, good afternoon, good evening, and good night. And remember, nobody can stop reggae.